All right, our second case today, Stephen Miller versus Caroline Miller. Good morning.
Good morning, Your Honors. My name is Andrew Roy. May it please the Court. Your Honors, I am the appellate counsel for Major Miller in this case. I'd like to reserve 5 minutes of my time for rebuttal.
Sir.
Your Honors, if settlements are encouraged or even favored, especially in family law matters, then they have to be meaningfully enforced if parties are to go through the effort to actually resolve their differences. In this case, the parties, after contentious litigation, reached a global resolution of all issues that were between them and documented those resolutions in an agreed parenting plan, a marital settlement agreement, and a final judgment which approved both the parenting plan and the settlement agreement.
Counsel, I'm going to just go ahead and get straight to the question here. In your initial agreed parenting plan, as page 8, you specifically say that the time-sharing schedule starts September 2018, or goes until September 2018. At that point, you left open what was going to happen. I mean, there were some basics. 50-50 time-sharing was encouraged. You had great detail about the military issue, which I understand, given the situation. But there was clearly zero agreement in your initial agreement about where these children would go to school or what it would look like when you had school-age children. So when your client filed the supplemental petition that he filed, it was clear he did not expect to be sent to Japan. And he asked for several changes from that initial agreed. He asked for primary parenting responsibility as it was related to education. He changed the designated exchange point. I mean, there were a lot of things that he asked for that was outside of strictly where does the child go to school. So why do you think that the court was in any way prohibited from addressing all of those relevant time-sharing issues in its final judgment?
So, Your Honor, absolutely right. As far as the parenting plan was concerned, the parenting plan originally had a lot of elements in there, and there were 2 pieces that were supposed to be addressed later. And the supplemental petition does address those elements. But the supplemental petition also addresses several other things, as Your Honor said, but some of that is temporary relief, and the vast majority of that supplemental petition goes to enforcement of the existing parenting plan because the wife was refusing to actually comply with it. And so the vast majority of those things, if we go through the list, the adjustment to accommodate orders to Japan, that's not a modification. That's just a matter of enforcement because the wife was refusing to accommodate that. In fact, the original parenting plan contemplated that Major Miller would be sent outside of the United States. That's not deployment, just to be clear. That's actually a change in duty station orders. Still can have children with him. It's still accompanied.
And the judge was very harsh on the mother in the final judgment of modification about those non-compliance issues. I'm just trying to understand your argument that, I mean, clearly time-sharing had to be altered. There's no way you're going to have 3 weeks on and 3 weeks off when someone's in Japan and someone's in Florida. So what exactly is it that she altered that was not requested or opened by your client in that?
Your Honor, yes, absolutely. The time-sharing would have had to be adjusted, but it was always going to be within the context of, or the construct of 50-50 equal time-sharing. So that percentage was built into the original parenting plan. That wasn't necessarily changed by the court. It was actually adopted, but there was a question as to whether the 50-50 was even going to stay. And the trial court in its final judgment, in the opening paragraphs, talking about why there is a substantial change in unanticipated circumstances, actually cites that Major Miller asked for full-time custody of the children. That's not true. Major Miller asked for, as Your Honor stated, being a custodial parent for education purposes, but still maintaining the 50-50 equal time sharing. And so throughout all of this, Major Miller was trying to continue to comply with the original parenting plan, which was part of the entire settlement, which is that they were always going to have 50-50 time sharing. It's just what the rotation looked like was going to be a different story, and where the children would actually go to school was also going to be determined at a later time, which, where the children go to school, the court cites the parenting responsibility and everything else that was requested in the modification or the supplement from both parties. That was going to have to be addressed, and it was contemplated the parties that it was going to be addressed. The settlement agreement itself actually says that until such time as the parties come back to the court or reach an agreement as far as where the children go to school, there will not be determination of custodial parent.
So where do you feel that the error exactly is in this final judgment modification?
Outside of the child support, which I'll get to in just a second, but for the parenting plan itself, the major issues concern the provisions of the parenting plan. For instance, the new parenting plan as drafted by the court doesn't include attorney's fees provision. That was something the parties negotiated before. It just got stripped out. And there was no basis to do that because that wasn't asked for by the parties. So really what should have happened is it should have been an amended parenting plan based on the original form of the parenting plan with the time sharing piece adjusted to address the educational pieces. Some other things that were addressed that were basically stripped out of the parenting plan was the 6-month minimum for the military surrogate. So Major Miller's mother serves as a surrogate for him if he has to go on active unaccompanied duty.
You asked for that to be changed to a year, correct?
That's correct, Your Honor, but that was contemplated in the original parenting plan as well. So it said that one of the two issues that the parties were going to readdress was not just the education side, but also coming back and saying, what happens after 6 months? So the 6 months was always going to be that minimum.
So you don't think it was proper for the court to address what happens when he's gone for less than 6 months?
That's right, Your Honor. It was error for the court to strip that out to turn it down to like a 30 or 60-day availability requirement. That actually fundamentally changes the agreement between the parties because Major Miller will have occasions where he'll be gone for 30 days on unaccompanied duty, but that doesn't mean his visitation or his rotation should be interrupted because of that. And so the 6 months was the bare minimum that the parties had agreed to, set it up for later. They all agreed on this in the settlement. Set it up for later to have a determination of what happens after 6 months. And one unique thing that did happen here is that the new statute got passed in terms of the Uniform Deployed Parent Custody Act. So that did kind of changed things a little bit, but that's still not a substantial change in unanticipated circumstances. That is the hook the court has to have in order for it to modify a parenting plan that has already been approved by the court.
That kind of goes to my question. So this is procedurally, it was a request for a modification based on changed circumstances. Right.
It was agreed to that the parties would come back, and they actually agreed there wasn't going to have to be a change
but
in circumstance.
doesn't the settlement agreement though say when the parties came back, if it was consistent with the MSA, that there would not need to be an allegation of changed circumstances?
That's correct, Your Honor.
So how did the trial court err in reading a petition that's for modification based on change in circumstances and saying, a couple things didn't change, but there's these collateral issues that have changed and create a need? How is that an abuse of discretion to interpret that as issues beyond what the parties anticipated entering into the MSA?
It's an abuse of discretion because the nature of what the parties agreed to in terms of what the court could do and intervene in was very limited to those issues. It doesn't mean the court gets to write an entirely new parenting plan and eviscerate provisions that the parties specifically negotiated and agreed to. For instance, the attorney's fees provision. For instance, the minimum 6-month military surrogate piece. Those are out. Those aren't there anymore. The parties never contemplated those would be wiped out. Of course, the court can come in and say, yes, you're going to be the custodial parent for this period of time. And so the rotational thing, that was contemplated as part of what the court was going to be able to do. But the court went beyond that and just scrapped the parties' original parenting plans, didn't even adopt any of the proposed parenting plans, which Major Miller's parenting plan, I get it. At first blush, when you read the parenting plan, the proposed parenting plan, and even the supplemental petition, at first blush, if you're not digging down into it, it looks like, oh my gosh, he's asking for an entirely new thing. And that's just not the case. He didn't ask for an entirely new thing. He complied with the agreement the entire time, in fact, asking for 50-50 time sharing at all times, even though he wanted to be the custodial parent for educational purposes. And that's an important fact.
Isn't that a risk that any party runs when they go before a judge in a family law matter? I mean, it's not an agreement anymore. The judge does not have to adopt your proposals, either party's proposal. I mean, you are allowed, I mean, because you can't resolve it, you're going in front of the court, and the court is following, the statute and finding the best interest and creating a parenting plan. So how is that an abuse of the court's discretion?
Because there was not an unanticipated change in circumstance that triggers the court's ability to actually go and write a new parenting plan. That is what is required under the statute. That's what's required in the state law, in the case law. You have to have that unanticipated change in circumstance. The change in circumstance was totally anticipated by the parties. It was anticipated in the parenting plan and the settlement agreement and the final judgment. Everybody knew they were going to be coming back to go address these limited issues. I guess I can't say limited issue, but it wasn't that the entire parenting plan gets scrapped. It's that it gets amended to address the new parenting plans.
How anticipated was the change in circumstances? I mean, didn't they anticipate that perhaps he would go to Washington? That would be the change?
Your Honor, based on...
Anticipation that he would go halfway across the world?
It was anticipated at all times in the parenting plan that Major Miller was going to be subject to a change in duty station orders, including, I think the phrasing in the military parenting plan is that the distance is at a minimum of 2,400 miles away from the residence here in Florida. So it was always anticipated that that his change in duty station orders could have taken him to Japan. And the parenting plan even allowed for the parties to agree on a different rotation as long as it was still 50-50. So, in any event, the court abused its discretion by not having that necessary hook. Neither party actually pled a substantial change in unanticipated circumstance. The only thing that the wife had pled in her supplemental petition or her counter petition was that there was an oversight in child support. And that takes me to the child support argument here. Your Honors, before this supplemental final judgment, there's an agreement between the parties as to child support, providing that each party shall provide all support for the children when the children are with that parent. That is an agreement. That is a contract. It was incorporated into the final judgment. And now that we're here on appeal, we find ourselves where Major Miller's having to pay Mrs. Miller.
Do you think the law supports that parents can waive child support?
It does not support a concept that parents can waive child support for the children, but there is a distinction between the parties' ability to contract for child support is between them. And actually, there's the case that I think there's a few cases that are illustrative on this point. The first being the Heard case out of this court, and in that case, there was an agreement between the parties for an amount of child support that was lower than what the guidelines provided for, and the court ended up approving that. And then several years later, the wife came back saying, hey, I can't contract away the children's right to this additional child support, and the trial court agreed and actually set aside the child support judgment under 12.540, and this court reversed saying, you agreed. You had all of the information you needed to make that agreement. And it's not that the children were not being provided for. That's what this concept of waiver, an unenforceable waiver, is addressing. It's mostly in the circumstances where you have unwed parents and one of them, most likely the father, is like, I'm out. I'm not doing this. And you can have the kids, but I'm not going to pay child support. That's a waiver of child support that is unenforceable. That's not what we have here. We have an agreement between the parties that is enforceable in contract under the case law. And that is something that the trial court entirely eviscerated. The children were at all times going to be taken care of. It says that there's no need for any reciprocal payment of child support because both of them are fully capable of providing for the children when the children are with them. This is probably the biggest error here by the trial court, is undoing this child support agreement because it was in contract.
Let me ask you this. In your pretrial memo on page 26, it says, the former husband has taken the position he does not want any payment from Mrs. Miller. Now, under these circumstances, it goes on to describe those. The former husband father reserves the right to receive additional upward child support from the mother. Do you think that would constitute trial by consent at that point? He's essentially waived the argument that the court can't consider child support? No, Your Honor, and there's several reasons why. First of all, the trial counsel did move to dismiss the counterpetition for claiming that the child support was an oversight. That is the entire crux of this litigation. That's why it blew up this way, is because we thought we had an agreement.
And then there was a motion to dismiss. The trial court denied it without a hearing. It should have been dismissed right there. It just should have been dismissed. And then as an abundance of caution, because it looked like we're going to have to, like the trial counsel was going to have to go litigate this issue of child support again, that's when he sought to deviate from the child support guidelines out of abundance of caution, which the deviation seems to suggest that Major Miller should actually get child support, not the other way around. But in closing arguments and throughout the trial, Major Miller's trial counsel always argued that there was a breach of contract by Mrs. Miller because she failed to abide by the agreement, because she failed to acknowledge that there was an agreement for child support and basically asked for it to be set aside with not even following Rule 12.540, which is what was addressed in Hurd, which was addressed in the third DCEA case, Gentry. Those all came to the courts by 12.540 motions. They didn't even ask for that. They just said, we don't have to comply with it. And the trial court let them do that. And it led to all of this litigation. But Major Miller's trial counsel did preserve that and argued breach of contract in closing and argued it, I guess, tried to set up the concept of breach of contract. It was set up as an affirmative defense, too, in response, in answer to the counterpetition. So it was not waived. This was not trial by consent. Yet they did actually litigate the issue of child support, but it should have stopped at the very beginning when Major Miller moved to dismiss. And finally, Your Honors, just briefly on the rest of the child support, the evidence in this case is stipulated to, so we're not talking about evidentiary issues. And the evidence is stipulated to shows that Mrs. Miller has far greater financial capacity than Major Miller himself. It's not just an income issue, it's a substantial assets issue. The trial court refused to hear anything more about the assets, just focused solely on income, and said, I cannot consider anything as relates to assets because that will be diving into principal, and that's not income. Well, the statute says you can take into account the assets of the parties to deviate from child support, and that's what should have happened here. It shouldn't have been, assuming the court's not going to enforce the contract, then it should have happened where that Major Miller should have been
But is
paid
that an
child
abuse
support.
of discretion?
Yes, Your Honor, especially in light of the breach of the contract with the child support claim. If you put all of those things together, there's no reason for Major Miller to have come out of this having to pay Mrs. Miller, who has a net worth of almost $1 million, where he has a negative net worth. There's no reason for him to be paying her child support. Finally, Your Honors, I see I'm in my rebuttal time. The attorney's fees issues are straightforward as well, but one of the issues there too is where the court, again, eviscerated the contract. The parenting plan provides for prevailing party attorney's fees in any post-judgment litigation. The court ignored that and said there is no prevailing party. And we also claimed for prevailing part or for attorney's fees under need under the statute 6116. But most importantly, I guess beyond those things, if the court's not going to find that there's a contract or the court's not going to find need under section 6116, is the Rosen fees. Major Miller's trial counsel did try to litigate the issue of the Rosen fees, and the court said we're going to bifurcate it to deal with that at a later time. And Rosen is really much who caused whose fees. And so you have to get in the nitty-gritty of actual fees incurred. And the trial court refused to let that ever happen. So there's not been a hearing, really, on the Rosen fees. And so that was error for the trial court to address that as well. And Your Honors, I'll reserve the rest of my time for rebuttal.
Good morning. May it please the court, my name's Tom Pepler, and I represent Carolyn Miller, the appellee in this case. The controlling facts in the record are clear. The trial judge's order makes it clear the parties did not have a parenting plan that applied after September of 2018. The 50-50 time sharing in the original plan by its terms ended in September. The plan provided that if the parties could not come up with an executable plan, that's the term from their agreement, they could go to court for a resolution. That is what they did. And the trial court recognized this fact as a predicate for its order. The standard of review for a court-imposed parenting plan is for an abuse of discretion. Appellant argues that this discretion is narrow when the court is modifying a previous plan, but we submit that that is not the case here. Because the original plan ended in September 2018, there was nothing to modify.
And so what would your response to the argument be that, yes, it was framed as a modification, but it was really trying to, the parties requesting the judge to get involved in these discrete issues that was contemplated by the MSA, and that anything beyond that would be an abuse of discretion because it wouldn't have been unanticipated?
The issue is that the contract specifically contemplated that there would be, if the parties could not agree to a new parenting plan after September, that they would go to the court and have the court resolve that issue, which by definition means that they had contractually agreed to go to the court to get a new plan, and there is no abuse of discretion.
It doesn't say a new plan. It says they will go to court to resolve these issues, and it does very much narrow that. So it's your contention that every other negotiated item in the parenting plan was completely up for the court to consider without any evidence of substantial change of circumstance.
Well, we have the agreement that says that they didn't have to plead that, but my position and my client's position is that the fact that the 50-50 time sharing while the children were going to school as contemplated in the original plan was such a dramatic change, they're in different hemispheres now, that the entire issue of how everything that was involved in the current parenting plan flows from the fact that the parents are not going to be living in the same hemisphere.
Even attorney's
fees. So everything else has to change.
Now,
they're still controlled by...
Counsel, attorney's fees for prevailing party has to change because they live in different hemispheres.
The provision in the contract says that it's in a specific paragraph in resolving conflicts involving the terms of the parenting plan. The terms of the parenting plan cease to apply after September, so that particular provision, if it's a prevailing party, dealt with arguments over the enforcement of the existing plan for the 3 years that it existed before September of 18. That is in the document. The document says disputes over terms of this plan. It's our position that after December 18, there were no terms to enforce, and indeed, the issues presented to the trial court had nothing to do with the terms of that plan, with the enforcement. At one point in time, my client did get assessed fees for violating the plan. The husband's counsel didn't like the amount, but the court did make that finding and assess fees. But after September 18, the parties both asked for a completely different plan. The pleadings are very clear about that. The prevailing party issue would not apply to that situation. It's not I would submit that it's not a reasonable reading of the contractual provision and the intent of that provision. I recognize the court can read the contract on its own. That's not an abuse of discretion. But if you look at that paragraph, to say that the last sentence doesn't have anything to do with the first sentence, in my opinion, is a non sequitur. The first sentence says it's disputes over the terms of this parenting plan. There were no dispute over the terms of that parenting plan. There was a request for a new parenting plan by both parties.
Well, I mean, in the counter petition filed by the former wife, it says, in the event they cannot agree, either parent could file a supplemental petition seeking a court adjudication as to the contact schedule. And then in the final paragraph, she asks for, them to designate Florida as the residence permanent of the children where they would attend school, award husband contact, and require the husband to pay child support. She doesn't say anything about modifying all the other provisions of the parenting plan, such as the surrogate parent issue or the surrogate issue in the military, the attorney's fees issue, and those things in her counter petition.
Well, step by step, the issue of the surrogate issue is controlled by a federal statute and Florida statute, and the judge made specific reference to that in the final order. The prolix references to that in the original settlement are basically parroting the statute. So there was no change in that one way or the other. As to the attorney's fees, that was a thorny issue when we were doing the pleading. It would be disingenuous for me as her counsel to say that we're entitled to attorney's fees under the contract when I don't read the contract that way. And accordingly, we did not plead for fees because we did not believe that contract applied, because it was strictly over the argument of the terms of the contract. And in this litigation, There are no terms in the original contract that were being argued about. There was no, he could argue that there was terms about the attorney's fees, but it just simply didn't apply.
Right, I understand that. I understand you weren't asking for fees. I'm just saying you were not asking for those provisions of the parenting plan to be changed.
The attorney's fees provision had, I guess that would be the case when the new contact schedule was imposed. If there was litigation going forward, perhaps that they would apply, but that's not the same thing in my mind.
Talk, if you can, a little bit about the child support issue. Do you think that the contract, the provision in the agreement as to child support is a waiver of child support?
That's exactly what their position was at litigation. The husband's counsel specifically said, well, we can knowingly waive child support simply based on the fact that we agree that both parties have ample funds to take care of the children. That is not what the case law requires.
Not really waiving support, that's waiving the obligation to pay support. These guys are saying we each have plenty of money, all the children's needs will be met when they're with me, all the children's needs will be met when they're with you. They're waiving the obligation for one to pay the other. Are you calling that a waiver of child support?
The waiver of child support and waiver of obligation to pay child support, in my mind, are exactly the same thing. The case law is very clear that the issue of not paying child support can only be addressed where there is a specific offset, where the parties agree that I'm paying for these extra things over here that are above and beyond, and that offsets my obligation to pay child support. All of us in the practice have had cases where the child support comes out to be nominal because the offset of incomes is such, but you can't just say, the case is very clear, you cannot just say, I agree that we don't have to pay child support. The case law says that it's contrary to public policy to do that.
In this case, the agreement also says that there will be no child support. The only change in circumstances that might later justify child support is if one of the parties goes bankrupt.
And that, once again...
Hang on, the only thing that you allege in your petition, or the former wife alleges, is that there was an oversight. Is there any allegation to any change in circumstances, unanticipated material change in circumstances that would warrant the court getting into child support?
The change in circumstances on child support is simply the passage of time and the changes in the contact schedule.
Does that have to be alleged? Does there have to be any evidence of that? The court found that just this 2-year rotation period is a change in circumstances because the party's going to be solely obligated to pay the expenses for a longer period of time. Where's the evidence to support that? Was that ever alleged by anybody, or the court just came up with that to justify this establishment of child support?
The court went into detail about how it was assessing child support based on the incomes of the party and the extended times that it awarded as far as splitting the issue. The pleading that we filed basically said that we need a whole new adjustment on child support based upon the requested change in the contact schedule.
Where do you say that in the pleading?
And the reason why we refer to it as an oversight, although the court said that caused excessive litigation, is simply the fact that for some reason, there was an agreement that the parties don't need to pay child support, period, close quote, no factual findings, no support, other than they're both rich. That, in my mind, it was contrary to the case law at that time, and I assumed that the judge simply let it go past. The simple fact of the matter is that once we do have an issue where we're looking to change the contact schedule, where the children are going to live, and all of this, then everything else flows from that. The 2 years where they were going 3 weeks on, 3 weeks off, and traveling back and forth across the world was ridiculous, but that's what they were stuck with. Once the court made its ruling, then there had to be some kind of adjustment for child support. And the adjustment for child support is based upon the facts as the court found them at the time of the trial. And the standard is an abuse of discretion. There's no abuse of discretion here. She made a careful analysis of the parties' incomes and applied the statute properly.
And why wasn't it, why wouldn't it be an abuse of discretion to ignore the assets and the finding that, that it would all be diving into principal without an evidentiary basis for that.
Well, the case law is very clear that you don't just look at, we're talking about child support, you just don't look at the assets and say, well, this person has $10 million in a trust account, therefore we can adjust the child support for anything. The issue is, the cases are very clear that it's income-producing assets, so you look at the income from the assets, and the court did that. The court did the analysis of what her assets were and what the appropriate income would be. And indeed, we had an odd thing at the trial. Up until like a week before the trial, the former wife was receiving regular payments every year like clockwork from her grandmother's trust. And we included those payments, those regular payments, in her income. Then a week before trial, the grandmother died, and the legal basis for that stopped, and the court pointed out in its order that we can't use that going forward. Now, we stipulated for simplicity's sake that that's what she's been living on. We assume that she's going to be living on that going forward, and we used that same amount of money per month as our stipulated income, and the court used that higher number than the number that she would have found once she imputed income from all the assets that the former wife did in fact have that could generate income, to include real estate assets. As to the attorney's fees issue, Your Honor, the court's order is replete, and the record is replete with evidence that this case was grossly over-litigated. 150, 200-page pleadings filed. The counsel argued that all of this was because of a failure to provide discovery. At the beginning of the trial, at the end of the trial, the financial affidavits were essentially the same. There was exactly one order entered compelling financial discovery, and it was in favor of my client. The court used the Rosen standard and the other standards, need versus ability to pay, and properly found within its discretion that there was no attorney's fees to be awarded under that theory as well as the other. And as to the prevailing party issue, assuming arguendo that it applies, the court has discretion to say that given all of the litigation that was involved, I do not find either party to be prevailing. And she did make those findings as an alternate. So I don't think that there's any way to show that there was an abuse of discretion in her failure to award attorney's fees under any theory. If the court doesn't have any further questions, I'll rely on my brief.
Okay, thank you, sir.
Thank you.
Your Honor, I'm going to start with just, is it a contract or is it not a contract? Like, what does it mean in this case if not any aspect of this contract remains enforceable in this supplemental judgment that is enforced by the court, that the court ultimately enters? What it is the trial court coming in at a second look and supplementing or substituting its judgment for the judgment of the parties when it entered into the settlement agreement in the contract. There is a plain agreement for child support. The child support agreement provides that neither party has any need for child support payments from the other party. Both parties are fully self-supporting and are expected to remain in the financial condition until the children reach age of majority. This was not just an agreement that was supposed to be temporary, even if the court finds that the parenting plan expired in August of 2018. Even if that's the case, and the court reads that by its terms, and it has to read this contract by its terms too. It has to enforce this. This was an agreement for child support for an indefinite period of time, as long as the children, until the children reach age majority. And as Your Honor said, the only change in circumstance would truly be if there's a bankruptcy or if there are no longer any marital or non-marital assets. Those are the changes in circumstances. That's just like the court's, the third DCA's decision in Gentry versus Morgan, where there was an agreement by the parties as far as what are the conditions for modifying child support. And it had to do with different levels of income. If the father's level of income went over a certain amount or below a certain amount, only then can there be a modification. And in that case, the wife asked for a modification, even though those conditions weren't met. And then the husband asserted an affirmative defense of the contract, and then the wife then moved for relief from that judgment under 12.540. The trial court gave it to her, and then the third DCA said, no, this is an agreement. It has to be enforced between the parties, especially since it was approved the first time by the trial court because it was in the best interest of the children at that time and prospectively. That's exactly what we have here. And Your Honors, in relation to the prevailing party aspect and the determination that there was no prevailing party. Major Miller and his trial counsel, the court ultimately adopted the 2-year rotation, the 50-50 time sharing, so that Major Miller's prevailing on that piece. He should have also been prevailing party on the child support piece because it never should have been litigated again. It was already established. In our minds, in Major Miller's mind, it was a token for Mrs. Miller to have him pay child support so that the court could get around having to award an attorney's fees provision in this case. Early on in the case, the trial court said that no parties are going to get attorney's fees in this case. And so because of that, it seemed that became a self-fulfilling prophecy at the end. And so, Your Honors, I would ask that the court reverse the trial court's supplemental final judgment as it relates to child support because there was an agreement that was eviscerated by the supplemental judgment and because the terms of the parenting plan that were originally agreed to were also eviscerated. Thank you.
Okay, thank you, counsel, very much. All right, we're going to take about a 10-minute recess, change the panel, and come in and do the case of Weiss v. MSR Partners, et cetera.